Hey, everybody. Thanks for the chance to be with you today. I'm Jules Polonetsky. I'm CEO of the Future of Privacy Forum and the chairman of the PrivacyTech Alliance. I'll say a little bit more of what that is, but I got to just say thank you, Lourdes. It's been amazing to see you got some real old timers in this group, and we've been many of us doing this for 20, 25 years, and it's been great to see a rising star who I think we first met as a student, and the amazing work. There are a lot of really good legal and privacy people, and then there are people who know how to get stuff done and build things, and they're not often the same people, which is probably why privacy tech, frankly, hasn't come into its own until relatively recently. Those of us who thought we had the wisdom of the compliance needs could not conceive that you could actually build programs and technology and systems that could scale, because it was also complicated and complex. We are just not builders and operators, a lot of us legal and compliance people, and to see folks like Lourdes and the people in the community who are bridging these and really turning it into a business and something that scales is remarkable. Most of our stakeholders at the Future Privacy Forum are the chief privacy officers of the world. And so our motivation in helping and supporting is to make sure the products that are available actually exist and suit their needs and scale, and are available not only for companies, but for cities and for schools and for researchers. Many of the other stakeholders we deal with increasingly are struggling with the same issues, may not have the budget, may have the budget, but be harder to sell to, or may have somewhat different needs. If I'm a city leader managing an open data project, same underlying nuts and bolts, but perhaps nuances in how I'm regulated or the kinds of issues and stakeholders. So eager to help progress that. Let me quickly ask my colleagues here. We've got an awesome group of people. Let me start with Hilary. Let me ask them to do a quick, who they are and why you ought to be listening and weighing their words from where they sit in this part of the world. Hilary?
Hey, Jules, thanks. And I was thinking, as you were saying, going back 20, 25 years, yes, it's been a long time since we've been doing this privacy thing, and it's been exciting to see how it's evolved. I'm Hilary Wandall. It's great to be a part of this dialogue today, the first ever Rise of Privacy Tech Virtual Summit. I hope there are many more to come. I am the General Counsel and Head of Privacy Intelligence at TrustArc, and I have been there for almost 4 years. Prior to that, I served as the Chief Privacy Officer at Merck, a company I was at for over 20 years. I started there as a scientist and ended up in the law. And one of the goals I had before I left there was to figure out how best to bring insights around privacy to all the right stakeholders in the organization. It became very clear to me the only way to make that happen was with really good technology. So I'm delighted to be part of a space where we're trying to figure this out and actually bring all the stakeholders together within organizations to make really good decisions about data in a responsible way. And we know that privacy tech's the only way to make that happen.
And Andy, you're unique in a lot of ways as well, in that you've been both a major company CPO, a major mid-sized company CPO, and a privacy entrepreneur. So tell us.
Yeah, it's we've known each other a long time, Jules. The world has changed a lot, and I'm currently Chief Privacy Officer at Intuit, and I founded payment startup Privacy.com. And I think we're just at the stage of development where enterprise privacy is really taking off, but there's definitely another stage to come on consumer privacy. So it's been a long journey.
When I first met Andy, he was one of the senior privacy folks at American Express as well. Fatima.
Yeah, I'm Fatima Khan. I'm currently Senior Corporate Counsel at Okta, where we really take privacy seriously and invest in privacy as well. Prior to that, I was the Chief Privacy Officer at a company called Demandbase in the mid-size arena. I've been working in privacy for the last decade when enforcement for privacy really started to ramp up with the Obama administration, and building privacy processes in-house as well as product products that take into mind privacy. So it's really exciting to see this group come together and especially focus on the interdisciplinary nature of privacy and bring together the technologists with the and the entrepreneurs with the legal side. So excited about this event and this group.
So I started with the skepticism, I think, that I had when first sitting down. I was on trustees board when they were a not-for-profit, and I remember, meeting Kabir and saying, how is this, possible? These are complicated, high-risk legal and privacy decisions. Teams of lawyers need to be involved. How do you build a, scalable, technology-supported business? It's either big law firms, high-priced consulting firms, or niche consultants, and maybe they need some tools. But so much of this is so legal privacy dependent. How does one actually, build something that can be sold at scale in the way that investors, need not lots of human bodies, but tools that scale. So one of the things we wanted to focus on here is how you're all seeing market opportunity around taking these risks and helping, at the end of the day, organizations manage them now that everybody in the world's got to spend time and resources on privacy management. So I think we want to talk about some of the sort of risks that founders or startups need to be aware of, which is what makes this, a little more challenging than the typical, business where, I roll something out and if people like it and they use it, the downside is, they watch my entertainment or they don't. Here, you're rolling out infrastructure that misused, not developed properly, not in sync with the latest guidance, creates certainly a lot of legal risk for the users, if not perhaps sometimes even for the builders. So privacy pitfalls, legal pitfalls. This is becoming a highly regulated area, and you're providing tools to people that are doing incredibly complex, high-risk activities. Hilary, guidance. You came in to TrustArc, having lived as a legal lead, as a privacy lead. You probably had that skepticism and then actually saw the opportunity. What are the kinds of things you see that are privacy and legal pitfalls that need to be navigated successfully as one of the lead players in this sector?
Yeah, it's an interesting question, Jules, and I think an important one for us to think about, because on the one hand, as I shared earlier, like my reason for getting into the space was a goal in part to try to simplify the way in which organizations figure out and navigate the complexity of all of these laws and regulations. I oftentimes will show, like looking at your backdrop of all the books, will show people the stack of all the laws I have printed out just as I'm looking and trying to navigate through what the different requirements are. And it's a lot, as we heard on the last panel, for people to figure out. One of our goals, and one of my goals personally, is to take all that complexity and design technology that actually can simplify the way that the requirements get presented. And so that in and of itself doesn't necessarily deal with a lot of personal data per se, but I would say one of the legal risks there is technology can't provide legal advice, at least not under the laws with respect to providing legal advice and licensing lawyers today. You can't license a technology to practice law. And so we have to be very careful in how we design the technology to make sure that it is not stepping across the line, if you will, in terms of purporting to provide legal advice, making sure that it is recommendation or guidelines. So you can design incredible algorithms. It's something we spend a lot of time on, is designing rules and algorithms, a lot of logic that can look at metadata to determine the likelihood that particular law or certain components of the law will apply. But you need to make sure that in doing so, you're not coming up against the unintended provision of legal advice or purporting to do so. So that's one key thing I would say we think about all the time. The other thing that I would comment, just to get started, that is a key area of focus. Is so many, and in the last panel they talked about it a lot, so many folks are focused on trying to determine, what data do I have? I can't solve this problem unless I know, what data do I have, where is it, who's accessing it, for what purpose, how's it being shared, all of those things. In order to determine what data you have, there's oftentimes a need to deploy scanners and other methodologies to discover the data. And in doing so, those scanners and other technologies are actually touching that data. They may be touching it in a way that doesn't actually render it in identifiable form, but I've seen quite many that actually do produce data that actually is identifiable of individuals. And so in helping to solve a privacy problem, you're actually creating a privacy problem. And so making sure that the design of the technologies is actually aligned with core privacy by design principles, core privacy engineering requirements, and privacy tech is engineered appropriately from a privacy perspective is a really important thing. What we've seen with a number of people that we work with is oftentimes some amazing engineers and technologists that are getting into the space have a tremendous security background, really understand technology, but may not have a sensitivity to the fact that as soon as you start using personal data, you're triggering privacy requirements that you need to be considering in how you're designing.
Yeah, I recall being at a booth at IAPP and being shown a demo from a vendor who showed me how easily, he was accessing, raw consumer data at a company database in order to properly categorize it and so on and so forth. But I'm like, wait a second, who's allowing some vendor or even any random employee to easily go to the heart of, actual customer data like that? Aren't you running afoul of a whole range of challenging security issues? And this was years ago, so hopefully those sorts of things have been well dealt with. But are there other areas, Fatima or Andy, whoever wants to jump in first, where but vendor companies themselves can be legally creating risk by what they do? Obviously, how they access or how the tools themselves access data, and whether that becomes subject to compliance. I don't know. Another example, and I wonder how you avoid this, is the cookie classification. At the end of the day, I'm relying on you to scan my site and classify and put things in the right bucket, and I guess I better review it and make sure it's right. But there's a big default decision there that, depending on how you draw the line, could put my company deeply in or out of compliance. The Dublin Irish Privacy Commissioner did a sweep, and in their report criticized some of the CMPs that companies were relying on for the way they were, misclassifying, or the way they were handling the consent, and more or less sort of pointed the finger. Hey, everyone's out of compliance because they're just using the default versions of your tool. So how have you handled that? Maybe Andy, you're now a customer of some of these tools. What frustrations have you had in terms of the way the tools are supporting your legal work?
I think we ended up building a lot of proprietary processes and documentation. We work with a lot of vendors. Vendors can be super helpful, but I think that there's different layers to the infrastructure. And from an in-house perspective, we've taken the approach of building our own systems and processes.
And that's not necessarily because you wanted to at the outset. If it was there, you would have been more than happy to plug it in.
Yes and no. I think that I was going to say probably the biggest pitfall is for people who've been in privacy for a long time. We're skeptical that we'll get a federal privacy law, but at the same time, we know directionally where everything is going. Where this is a business imperative now to do these things, and so I think that you have to be building data subject rights machinery. You have to be doing things now, irrespective of whether a law is driving you to it. So I think the privacy pitfall could be getting too caught up in the esoteric nature of privacy law, which was quoted by one of the founders earlier, and instead thinking directionally, we're moving to GDPR-like accountability framework for the world. We're getting, certain rights and laws, And also, I think privacy is becoming profitable. And so I think that there are pitfalls in using the tools. The tools are tremendously helpful, but there has to be buy-in from the company that this is happening directionally and invest in things that can scale.
So maybe there are companies who really only want to deal with, I have a legal compliance problem, give me the software that's going to help me. And folks that are thinking more holistically are saying there are data subject rights, whatever the specific requirement in each country is. I know that there will be law, there is law that is mandating this kind of capability. Give me the capability and I'll worry about modification for legal
I think
compliance.
that's the stuff that's we're in the stage of development that's the stuff that's receiving funding because there's enough sensitivity from investors and the world that this is happening now and you have to actually execute on it. And so I think that is spurring a whole round of funding around sort of enterprise SaaS privacy. But there have been some great solutions already.
Yeah. Would you think, and maybe Fatima, I'll bring you in here, is this perhaps differentiated by different parts of the market? So a big sophisticated company with senior folks like you, right, are looking at, hey, it's a core capability of my company to be able to manage data in this way. And then there's compliance things built around it. There's an awful lot of people who are simply, there's a cookie requirement, give me a thing that's going to handle it. I'm not thinking that deeply yet about what are the core functions companies need to have to build in, and is that a very different audience? Certainly, again, we deal with a lot of school districts. Nobody gave them any money, gave them any resources. Everyone gave them obligations, but we didn't give them any resources, and so they may just want to plug things in, and there's millions of businesses, right, SMEs around the world who don't have privacy lawyers and want to plug stuff in that is good enough. Anyway, Fatima, your thoughts
so
there.
As a buyer, I see a couple of different things. One is oftentimes software try to say our product solves for GDPR or our product solves for this law. And then that in itself is a privacy pitfall. As Hilary mentioned, you can't advise companies on how to comply with law. As Jules mentioned, the way that you classify cookies, that then comes on you and you're providing legal advice there. It's definitely geared towards more unsophisticated buyers that are just trying to solve for some problem that they know they have and do a checkbox. What would be really powerful instead would be to build these products so that there is a lot of choice and configuration availability built in. So whoever is implementing that product in-house or configuring it can then figure out how to implement it in a scalable way that will hit all of the nuances that different laws need to hit. Right now, that's not happening with a lot of privacy products. They're just looking at the GDPR or they're just looking at the CCPA and a very small sliver of it. So there sort of needs to be a shift in how privacy products are built instead of to comply with a specific law, but to empower the user to implement according to their own risk tolerance and their specific privacy program, similar to how security products are often built already to enable the security team user to do that in line with their security setup.
So one point I make when I speak to senior leaders at companies is this isn't anymore about privacy. The front page headlines 20 years ago were cookies and privacy and tracking and various other issues. And today, the reason these are global debates are because they involve power. Big companies have your data, startups have your data, discrimination, government access, platforms and the right regulatory balance and capitalism, right? This is now every challenging issue in society is happening on data, is happening on tech. And privacy is often the lever because you're violating my privacy because you're using the data in that way, but I'm unhappy because I actually don't like what you're doing, right? It's occasionally that I've exposed you and you're embarrassed, or you're going to get some spam, or there's actually some financial harm or like, but in many cases, as a number of prominent CEOs from, Apple to Google to Microsoft to every, global data regulator, it's about human rights, right? We're in the human rights business. GDPR famously doesn't say privacy, right? It talks about data protection in order to respect the rights and freedoms of individuals, which include a lot of other rights under the charter. That's why this is global drama more than there's just kind of a lot of this regulation happening here and a lot of people are responding. And you could obviously be very compliant with the details of specific regulation and still be in a lot of hell and a lot of hurt over what you did with consumer data at the end of the day because of people being unhappy about it. So and we're starting to see that criticism already. Professor Ari Feldman, who's been writing about the corporatization of privacy compliance, right? This is ethics and human rights, and you're solving it with like a tool and a checkbox, right? And that's not actually, that's almost diminishing, right? I solved my human rights problem because I went through my tool and I, adjusted it to the right settings, right? Of course you didn't. So how do we bridge between, the fact that at the end of the day, scaling things, organizations need systems. It's mundane, right? But like that's how systems work at companies once you have the values set. But we seem to have this disconnect between the bigger picture drama of what's really driving this activity, right? We ain't going to stop complaining about Google and Facebook because they've got GDPR compliance down, right? We're going to be debating, hey, what's going on? Is this the right balance? So can you guys react to that? How can startups and the tools here be understanding and supportive of the much bigger drama, the power, the what's really going on in the world? Hilary?
Yeah, one of the things that's coming up more and more, Jules, is exactly that question. I think more so from some of the more sophisticated leaders in the space, but I think it's becoming an issue for a lot of smaller companies as well. And we're seeing it introduced in regulation, not just GDPR, but other regulations, thinking more about civil liberties and rights, if you will, not just about core obligations of organizations, and the balancing of those two things is really critical. So I think, one of the things that tech can do to help is making it more than just automation. I think automation itself is obviously critical. Ability to find, detect the data and figure out what to do with the data is really what organizations need to do. And one of the things that we see often is and even introduced in the regulations now and some of the state legislation, is how do you look at societal benefit or organizational benefit and balance that with risk? And there are vehicles, I think, that technology can provide for organizations to be thoughtful and consistent in evaluating privacy risks. I think I've had a few discussions with people recently about the fact that privacy is an area where risk has not been well understood or defined, and in very few organizations has it been tied off to things like security risk or third-party risk management or broader enterprise risk management. Some organizations have done that well, but a lot of organizations don't even know how to begin to get started because they're oftentimes thinking about privacy as a black and white or a check the box, I did exactly that. And the nuance, the ethics around managing data effectively requires that you really understand those whom you're using data about, and what their interests are, what your interests are, what the broader societal interests are, and being able to do that benefit risk balancing in a way that is both subjective and objective at the same time. And I think there is a need for technology that helps support an understanding and a balancing, not in a black and white way, but rather in a gray, nuanced way, doing that consistently and enabling it to scale so it can be tied into enterprise risk management. We know there are other areas of the law. For example, environmental health and safety issues, where the similar needs of individuals, society, corporations have been able to be balanced. They have found ways to actually introduce technologies to support ongoing evaluation there, and it's something I think the privacy space really needs as well.
Thoughts from you two on this? Am I being a little too esoteric here, saying that startups providing technology tools need to be human rights experts? Or I think Hilary has given us a sort of a framing that brings those together. But what do you guys think?
So basically, what so many prior risk management frameworks and so many other big policy issues, such as this one, or diversity and inclusion, or other areas that are important, they just keep getting relegated to contractual exhibits or contractual amendments. And I think really that the privacy regulatory space is sort of at an inflection point where it will either go into that contracting Article 28 type world, or it's going to move into something where it's really integrated into the technology we use day to day. And that's really where privacy startups can provide value, is creating a user experience and making those tools available for end users. So it's expected to be part of any technology company or any company using data and that experience, rather than just being like, hey, we have a contract in place, we have a privacy policy in place, you email us, we'll figure out how to get this information to you. So we're at a point of change right now where startups can really make a difference to integrate this into user expectations, and it does become more of an awareness and human rights issue rather than being a check the box.
Andy, it feels like the field is still, despite some very mature companies, TrustArc, OneTrust, others who are here, it still feels like whenever I talk to chief privacy officers or legal leads, and I probably talk to 20, 30, 40 a week just between various things we're doing, they all still feel that there are big gaps between what they really want and what is still in the market. It feels like this is still very wide open, and that even the leaders are just scratching the beginning of what this looks like. I hear things like the integration was really, really, really hard, and everyone hates me now, at the company because I said this is going to do it, and then all of a sudden there was lots of IT and engineering support that had to be done, and it was supposed to be easy, right? Or we really had to do a lot of customizing. And now it sounds like you, from your seat, that was maybe fine because you wanted and needed to do some of these core capabilities for the company. But it does seem like not everybody wants to do all of those things if they can, rely on a vendor to, carry a lot of the load, and that there still was a lot of customization and so forth. Am I kind of reading the room right? That
but I think I agree, Jules. I think it's a continuum. If you're a big tech company in Silicon Valley, then this is a bigger issue to you than compliance with CCPA or whether worker CCPA comes in. It's like, this is fundamentally how your data is organized. And so I think we're seeing privacy engineering teams at a lot of companies, and we're seeing it move down the stack from an over-the-top solution, which is what I think is very helpful to most companies and smaller companies, to other companies building it really in by design because it's so essential to defining the amount of data that you can use, how you can use it. And then, to me, it's not, I don't think that startups need to be human rights advocates, but I think taking privacy seriously for what it is, which is a fundamental human right, and understanding that that we have biometric privacy issues now, which we never had before, where people have unique fingerprints, and you can read somebody's heart rate and have a signature from it to know who it is. And so they're very serious issues. And so I think there's a full range of companies that can come and serve this space. And I think it depends on how important privacy is and using data is to that company and where it sits in that stack.
How much time, the question I hear sometimes from data commissioners is they're worried about the SMEs not having the tools, or when they do reviews, even though they want to squabble with big companies, often they're seeing the incredible gap that exists, for the dentist's office and for the hospital and for, I mentioned schools, government agencies around the world who, right, are subject to GDPR, have some really complicated, issues and customer service, and aren't always the lead in IT, so are maybe even more heavily dependent on vendors. So the SMEs really do want a little more lawyered in the box solutions, right, that tell them what they should be doing to comply with their legal obligations, right? For better or worse, that's a lot of the SME world. So Hilary, you guys have a pretty wide swath, of customers, from big global companies to, smaller players who are using bite-sized amounts. Do you find that, for companies who want to serve that market, you really do need a legal team advising and shaping the product, and you need, I know you stay in close touch with regulators and, follow and are part of, right, the let's take a really long, expensive, important process, the APEC process and the cross-border rules, which you were involved with at Merck, and TrustArc plays a role in. That's big, long, expensive, sophisticated work with years of investment to, be able to help make that happen. How much do people need to be saying, if I'm going to serve SMEs and I'm going to, stay tuned to what is needed from different regulators, does everyone need a legal and policy team? It seems few have them because it's expensive. Yeah. You and some of your staff do support that at TrustArc. What's your take on that?
I think it depends on the actual business goals of the particular privacy tech company. I mean, in our case, one of our areas of focus is actually bringing the privacy knowledge and intelligence to the tech. And so because we chose that space versus some of the other spaces like de-identification, for example, DID is critically important. It's an area I've been thinking about and focused on for much of my career, going all the way back to being a research scientist. It's not an area that we do a lot of work in directly. That's an area where certainly there are de-identification requirements in a variety of different laws. And there's like technical specifications to consider there. There is not much of a need, I think, to have in-depth understanding of all the different laws and regulations in the world that then get built into the tech. I mean, making sure you're considering what is de-identified, what's anonymized, what's pseudonymized, and all of that matters. But the degree of understanding of the nuances of, for example, different regulator opinions on whether or not taking temperatures before you let people back in the office, like, it doesn't matter so much there. Like, what we provide in terms of our tech is very much both based on the different requirements around the world. And so we do need a team that is able to take all of those different regulatory updates, legal opinions, court decisions, and boil them down into things that can be objectively consumed in a much more simplistic way. And so that's why we've invested in that way. Obviously, that has to be balanced with the investment in engineers and developers who can actually take a lot of the rules that we write and then code them into the system. So we don't do that ourselves, but there's a real balance there that maybe isn't needed in every space. I think it depends on where you are in the stack and what you're trying to serve, is how I would characterize it.
How much does the investor community need to understand when and which areas here really have a there? Again, I know during many of my years, once a month, once every 2 months, I'd hear from somebody on the investment side because they'd read an article that data brokers are going to be illegal or cookies are going to go away. And, for 20 years, that wasn't really happening. And they kind of wanted to know, do I sell or not? Because I read that, Europe's going to ban cookies or something like that. And and the answer always was, well, there's legal risk, but probably not going to happen in a way that dramatically changes the business landscape, right? And all of a sudden now it's changing, right? Yesterday, Apple said IDFA, the ad tracking tool for iOS apps, opt in, please. Cookies, right? All the other browsers have already started blocking, and all third-party cookies, and Chrome will soon do so. So bam, right? That business just changed. And presumably companies that are looking to solve problems in that space, the business imperative just opened in a way that it might not have. But you need to really be, steeped in when is, are we really going to have a federal law? Are we not? How much do founders sort of need? Go ahead.
So Jules, I love this because, for me, this is America, and I wish that people got on board with privacy because it's a fundamental human right. Ultimately, it hits a profitability tipping point. Just like salads and electric cars. At some point, it's not consumers that are demanding this change happen. It's actually companies that are realizing that if I want to have a business 5 years from now, I have to organize myself this way. And so I think, we still may not get a federal privacy law this year, but people are investing. There's serious systems issues to be addressed. The architecture wasn't designed for this. And so there's opportunities for companies that can help you with your existing infrastructure and provide an out-of-the-box solution that takes into account legal regulatory considerations, risk. That's awesome. But then also just directionally, companies have to evolve because this is the new profitability driver.
Right. And then for both B2B and B2C models, like if they don't have trust with their customers, then they're fundamentally not going to be able to do business and get that revenue in. So no matter if you're a small and medium enterprise or a larger enterprise, you're going to need to get that in some way. And it's either through an out of the box solution or through something like heavily customized by your team that has implemented it in-house. So everybody's going to need to adopt privacy technology in some way. How it's done, it will vary based upon resourcing as well as trust and revenue coming in. And then the prioritization will also matter by revenue. If you're a small company, you're going to be less concerned about adding in privacy technology because you're just trying to get those first deals in, versus a bigger company that will have it be something really important for its big customers.
Let me touch on de-identification for a second, because Hilary brought it up, and you said we don't really do that piece for some very complicated reasons, and at the same time it is also one of the areas where privacy professionals seem to have the most challenge because of, I think, lack of full understanding of how what exists in the market maps or doesn't map to CCPA, to GDPR. People still seem to not be clear on what gets me out or which technologies work for what use cases. So there are obviously some emerging companies sort of offering de-identification as a service, but it's still an area where people seem to be scrambling around for individual vendors, where the data science chops for it may not exist at companies. Is this our problem on the legal and regulatory side? Like, if we defined what was in or out well enough, we'd see people building to it. It's still an area where the technology and academic work is advancing and exciting, but in the company side, other than a couple of big tech companies doing really funky things with homomorphic encryption and a lot of expertise, it still seems there's a giant, I don't want to go there, I'll aggregate and that's it. But beyond that, it's too complicated. Thoughts? Is this an area where the legal knot is still tightly tied, and there are a few players, but it's still and at the end of the day, it's the holy grail, right? Avoiding the compliance, avoiding the risk, avoiding the harm, and actually supporting the utility of data. Is that a nut that somehow needs to be cracked?
I think I'll just say from my own perspective, going back to my days as a scientist and my early days in privacy, trying to help the researchers maximize what they could do in terms of secondary analysis without tripping up against, in particular, consent. So I think, I was in the health space, so we want to be able to use data sets, do all kinds of secondary analyses, longitudinal analyses, so you can understand outcomes better. And in that space, you oftentimes can't go back and get consent. And if you need to go through long reviews to be able to utilize the data, it becomes really problematic. So some form of de-identification that takes you out of the space of a consent requirement, I think, is what most people have and continue to strive for. I think it's unrealistic. I'll just say my own 2 cents at this point in time. It's unrealistic to think that use of data that relates to people can be fully outside the scope of a privacy law. I think that good data governance matters no matter what. And so setting aside whether you have a specific compliance requirement and focusing more in on how to use data responsibly, which means that it shouldn't always be fully identifiable.